Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So today I'm going to take a little bit of a risk and I'm going to talk about the oral argument at the Supreme Court, Donald Trump versus the United States. Now I want to make clear that I'm not taking a position. I'm not saying Trump should win. I'm not saying the government should win. I'm saying reach your own conclusions. To me, this is just about the law. Do I have a bias in this case? Yes, I do. But am I going to announce that bias? No, other than I will say this. I care far more about other cases that will follow than necessarily this case in front of the court. This case in front of the court is a blip in 234 years of Supreme Court precedent. But the decisions that are made in this case will echo down the halls of justice for a very long time. So let's talk a little bit about how oral arguments happen at the Supreme Court. The first thing that happens is the petitioner is the first to go. And the petitioner in this case is President or former President Trump. There is an opening statement from the lawyer, and then he gets peppered with questions. And the questions seem to go on forever. Then, after he's finished with his original amount of time, he sits down and his opposing counsel gets up and he does an opening statement, and then he gets peppered with questions. And then after the government, or the respondent in this case, finishes their portion of the oral argument, usually the petitioner has a rebuttal period. In this case, the petitioner waived its rebuttal, which is really unusual. You always want to have the last word, so to speak. And the other thing that's really interesting about that is that the respondent, the government, went for an hour and 40 minutes roughly in terms of questions. I guess probably an hour and 37 minutes. So they had a lot longer up in front of the court addressing questions than did the petitioner originally. It's interesting then that you would go ahead and waive your rebuttal after he had such an enormous amount more time to argue in front of the court. That, I think, means he had a great deal of confidence in the argument that he made. We'll have to see if that was a brilliant strategic move or a bungle based on the result, I guess. We're going to look at these two opening statements, and then I'm going to give you my analysis of the court's reading on this, just looking at the precedent. First, the Trump team.
We will hear argument this morning in Case 23-939, Trump versus United States. Mr. Sauer?
Mr. Chief Justice, and may it please the Court, without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
So that was the opening statement made by Mr. Sauer on behalf of President Trump. He then got hit with all kinds of questions. Again, I will tell you how to get to the transcript if you'd like, and you can read all of the questions. They are worth doing. That's worth doing. You should do it. You should listen to the oral argument or read the transcript. I personally prefer to read the transcript, but that's because I'm an appellate attorney. That's all I do is read transcripts. Now let's hear from the government's perspective.
Mr. Dreeben?
Mr. Chief Justice, and may it please the Court. This Court has never recognized absolute criminal immunity for any public official. Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. I welcome the court's questions.
So one of the things that's really critical here is the source of the power of presidential immunity. And according to the lawyer representing former President Trump, that's in the vesting clause of Article 2. So let's look at the vesting clause of Article 2. The Constitution speaks with few words here. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, he be elected as follows. And then it goes through the process of electing the President and all of that. Under Article 2, Section 1, Clause 1, the executive power is vested in a single person, the President of the United States. The nature and extent of that executive power is not clear. Article 2 identifies exclusive powers of the President, including the President's authority as Commander-in-Chief and his power to pardon. And then there are powers that the President shares with the Senate, including the appointments and treaty-making powers. And then the President's duties, the most important of which is the duty to take care that the laws be faithfully executed. Moreover, the Supreme Court has recognized that because no single person could fulfill that responsibility, in other words, taking care to execute the laws faithfully, the Take Care Clause implicitly provides the President with the authority to supervise any subordinate officers, like the Attorney General, like the Director of Homeland Security, all of those folks. Anyone who reports to the President, he has the power and the duty to supervise. Likewise, Article 1 provides the President a role in the legislative process, including the authority to veto legislation. Now, that veto, of course, is subject to an override by 2/3 vote of both houses. It's less clear from the text of the Constitution whether the executive powers expressly identified in the Constitution are exclusive or they're just an illustration of things that the President can do. The Article 1 legislative vesting clause provides that all legislative powers herein granted shall be vested in the Congress. That distinguishes powers granted by states from those that they retain. The Article 2 executive vesting clause doesn't limit executive power in any way. Consequently, since the earliest days of our founding, the parameters of the executive power, and especially what implicit or residual powers the President has, have been the subject of a great deal of debate. The nature of the presidency ranked among the most important considerations of the framers. Reacting to how royal governors had exercised their powers, the framers of the state constitutions had generally created weak executives and strong legislatures. Likewise, the Articles of Confederation vested the national government's powers in a unicameral Congress, meaning one body only. Experience during which the Articles of Confederation had been in effect led them to believe that an unfettered legislature, just like an unfettered executive, posed disadvantages, and that a legislature could not confer many of the advantages of a reasonably strong executive. So for that reason, the executive branch was thought to be, in some ways, a little bit more powerful than the legislative. Now, there are three co-equal branches, right? There's the legislative, the judicial, and the executive. And the executive does tend to have a significantly larger portion of the federal budget than do the other two branches. In this case, all of the judges ask really difficult questions, almost all of them framed as hypotheticals. What if the president decided to have SEAL Team 6 kill his opposition? Those kinds of questions, while pretty ridiculous in the abstract, officers and NCOs and even bottom line soldiers in the military are forbidden from executing an unlawful order. And the idea that you could be ordered to murder someone in cold blood is an unlawful order, and it would never be followed by our military. That's the way these folks are trained, and that's how they are selected. And so it is sort of a ridiculous hypothetical, and Judge Alito pointed that out during some of his questioning. Almost all of this revolved in some ways around precedent. So there are three critical cases here that are important. The first is Nixon versus Fitzgerald, which is a Supreme Court case from the Watergate era, and it held that the president had immunity for official acts. Clinton versus Jones, on the other hand, held that a president did not have immunity for unofficial acts. And the key inquiry then is what separates an official act from an unofficial act. And both counsel at oral argument had a lot of difficulty addressing that issue. And let's be clear, the court is going to have a lot of trouble addressing that issue. Now, Trump relied on the Blassingame case with respect to where the lines should be drawn. And what's really notable about that is the case it was decided against him in the D.C. Circuit. In that case, he was sued by people hurt during the Capitol riot on January 6th. He claimed he was acting in an official capacity and that official immunity should exist. The court did not decide if he was acting in an official capacity. They remanded that for a determination of which of his acts were official acts. Judge SCOTUS, however, offered some guidance in how to separate official from unofficial acts. And here is the most notable portion of Judge SCOTUS's concurring opinion. It starts with, and as relevant here, the president acts unofficially when he speaks as a candidate. Immunity attaches to functions of presidential action, not to the individual occupying the office of the president. How then to distinguish official from private presidential speeches on matters of public concern? The court stresses an objective inquiry into the context of the speech, substantially informed by whether it is clothed in the trappings of an official function, whether it is organized and promoted by official White House channels, and funded with public resources. In some instances, this inquiry will yield clear answers. This is not a case where the opinion will be out next week. It will not be out next month. In fact, I look for it to come out on the last day of the Supreme Court's term, right before their summer recess. And that's because this is going to be a very long opinion. Unlike the Colorado case, this will not be a unanimous opinion. No matter how it's decided, Justice Kagan, Justice Sotomayor, and Justice Jackson are positioned to deny immunity. Justice Barrett appears to be on the fence. Justice Kavanaugh has some reservations about that. And Alito and Thomas and Roberts do seem to favor some form of presidential immunity. Which means, of course, that even after the opinion, there is going to be a need for an evidentiary hearing to determine whether the actions of the president at that time were official or unofficial, and what specific criminal issues could go forward. Some of the oral argument dealt with evidentiary issues. What if we strike one particular claim from the indictment because it's covered by official immunity, and yet we have predicate acts under that claim that also go to other claims that the United States is bringing? That's going to create a real morass, and this is not going to be the last time this case is in front of the Supreme Court. Assuming that certain criminal issues could go forward, the evidentiary exclusions are going to be really difficult, and in some ways, they might make it impossible to prove that any crimes at all were committed, because the determination would have to be based on objective fact and not on speculation about motives. And because this is a criminal case, you can't bring in President Trump or former President Trump and ask him, what were your motives? The motives have to be determined from objective facts. And again, if someone makes the determination about motives, that too is going to wind up being appealed, and likely before you ever get to a jury. So this case is not on the fast track and will never be on the fast track. If you Google oral argument or Supreme Court oral argument audio, you can find the audio of the oral argument, as well as the transcript of the oral argument. I listened to about 10 minutes of the oral argument before I went to the transcript, because both of these lawyers' voices were like nails on a chalkboard to my ears. Now, the idea of cloaking a chief executive with unlimited power to avoid prosecution scares me to death. I can understand the need for immunity in certain contexts, but the rule laid down in this case is going to be the rule going forward. Whatever they decide, at least half the country potentially will be upset with that decision. They're going to have to draw lines, and they're going to have to draw bright lines, and they're going to have to color inside those lines, and they're going to have to say if you color outside those lines, your actions are not appropriate and no criminal conviction will be upheld. These are the kinds of questions and the issues that confront a Supreme Court. As I've said before, they are not just deciding this case. They are deciding every other case that comes before them on this issue of presidential immunity to a certain extent. The precedent established here will guide the other courts in the future. Now, does that mean that that precedent cannot be overturned? No, of course not. It can be overturned. The real issue may be whether it will be overturned or whether it even needs to be overturned. The judges on the Supreme Court, I think, are pretty bright folks. I think they will work very hard to put together an opinion, or in this case, probably a series of opinions, that do a lot to expose the problems with presidential immunity as well as the benefits of presidential immunity. And whatever decision they make, we'll follow it here on the channel. Thank you for being here. Again, I hope that I have brought this off without having a great deal of bias in the situation. I don't believe that that would be appropriate. I think that the judges have to be very concerned about any impression of being biased. This is a monumental case, and I hope that I have done you a service by going through it. I did not put a lot of audio up in here, and we did not go through that audio because you can listen to the audio yourself and hear some of these questions. I'm trying to give you a broad overview, and hopefully you will find that helpful. If you have any questions, put them in the comments down below. Again, we may wind up doing based on the comments, we may wind up doing a separate video about the comments, and we'll talk about some of them. If you have any questions, again, you can do them there. You can send them to me by email. If you send them to me by email and I use them, I'll block your email address and mask your name. You can count on that. And after you've had a chance to think about this and, put some comments on there, remember to be kind, remember to be respectful. That's really important, especially when you're replying to other people. I think it's really critical that we respect each other's opinions. And again, you can email me at the address above. When you're finished responding here, this is a reminder that, our country is sort of fractured a little bit here on these political issues. So even if somebody disagrees with you on politics, today would be an especially good day to do a kindness for them. When you do, you can come right back down here tomorrow and we'll talk about this or some other case again. Thank you. Have a great day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.